The Honourable Adam Searle.
Thank you, Mr Deputy President. I rise to make a contribution on the Law Enforcement Conduct Commission Bill 2016, and as my colleague, the Honourable Lynda Voltz, outlined, the Labor opposition does not oppose the legislation. In fact, the legislation that is before the House now emerges not originally from the Tink report, as the Police Minister in the other place and the Minister in this place would have us believe, but from a select committee of this House on the conduct and progress of the Ombudsman's inquiry Operation Prospect. And of course, as Mr Shoebridge previously indicated, there was not one but two upper house inquiries in connection with the Operation Prospect matter, which emerged from the unresolved and scandalous bugging of many police officers and others, journalists and others, which was not dealt with internally and was not dealt with by a number of the oversight bodies that existed, and was a running sore within the New South Wales Police Force, running sore for not one but 2 decades. And so deep and so poisonous was this lack of resolution that it shook the very foundations of the senior leadership of the police force in this state, in the persons of Deputy Commissioners Nick Kaldas and Cath, as was on full display when they were giving evidence to the Select Committee. And of course, it's a matter of record that Mr Shoebridge and the Honourable Lynda Voltz and myself, together with others in this place, served on those committees. And it was quite tragic to see the conflict and overlapping responsibilities of different oversight bodies had comprehensively failed to deal with this matter, and was paralysing the senior leadership of the police. And it must be said, it seems to me that this lack of resolution is quite likely to be the reason, if not one of the reasons, why Nick Kaldas chose to depart his position as Deputy Commissioner of the Police in the state. I acknowledge that interjection. We lost a very good man and a very good police officer. And of course, so as I said, the idea of a unified civilian oversight of police emerged from the Select Committee on the Conduct and Progress of the Ombudsman's Inquiry Operation Prospect, and I refer members to that report handed down on the 25th of February 2015, and in particular to pages 114 to 119. Those pages show that during the inquiry, several participants expressed concerns about the system of oversight of police complaints in the state, including the multiple number of agencies involved in the investigation and oversight of police conduct, and the conflict of interest inherent in the system where, of course, police can oversight their own colleagues. And several participants in the inquiry criticised the existing structural arrangements for police oversight, and it was noted, and I think previous speakers have indicated, that oversight, of course, is conducted by the New South Wales Police Force Professional Standards Command, the Ombudsman, part of it, the Police Integrity Commission, the Coroner, the Independent Commission Against Corruption, and even WorkCover all play roles in oversighting the police. And of course, the Police Association, representing its members, asserted that conflicting findings by multiple agencies had resulted in the loss of confidence of the members of the police force in a system where, and I quote, there are multiple oversight agencies. A matter may be assessed by one or more agencies as not warranting further investigation, only for another agency to launch a full investigation. In such cases, justice is put at risk and important questions are raised about the reason for the differing decisions and the appropriateness of the decision to investigate where more than one agency declined to do so, unquote. I note also in the 2013 review of oversight of police critical incidents, the New South Wales Police Commissioner had reported that oversight agencies collide in a way that was not intended and at times can impede police investigations. And as the Police Association in its submission to the Select Committee inquiry noted, dividing the functions, resources, expertise and organisational knowledge across multiple agencies has led to poor investigative practices and fragmentation of best practices and proficiencies, and of course formed the view that the existing situation involving multiple agencies was no longer fiscally responsible. And I won't go through the multiple costs of maintaining and running the Police Integrity Commission, part of the ICAC, and of course the Ombudsman, but it's quite clear that there is a multiplicity and a doubling up of work. The Police Commissioner in that inquiry indicated that his own view that whether a matters involving police, allegations of police impropriety or worse, corruption, his belief was that a single agency was the best solution. And he indicated in his evidence that it might be time to have a look at something like the Independent Police Complaints Authority, such as the United Kingdom has. And this view was indeed endorsed by Deputy Commissioner Nick Kaldas, who said, and I quote, "The framework that we have has sprung up in an ad hoc fashion out of various scandals. It is not a structured, thought-through process. It is simply we have reacted to something and we have said we need another body to do that, and so on. What we have now is a patchwork." So what the Police Association called for was, and I quote again from their submission, "a one-stop shop so that police officers are not dragged through multiple jurisdictions and subjected to multiple inquiries," unquote. Now, of course, the lack of confidence that the members of the police force have in the existing arrangements is, of course, an important factor for us to consider. And I note the contribution of the Honourable Michael Gallagher, who, of course, prior to becoming an elected member of this place, was, of course, a serving police officer. And I acknowledge that. So he speaks of what he knows. And but the point being that there are, of course, other considerations, because when you look at the lack of resolution around emblems, debilitating the police force for 2 decades, and other matters that previous speakers have spoken about, it's not just the doubling up or the overlapping responsibilities and the lack of clarity, or the lack, indeed, or the waste of public expenditure, but the delay and the unclear outcomes is bad for people who have become victims, whether that's the police officers themselves or people who feel that they have been mistreated by the police force, but also that is a very important public policy consideration, the lack of clarity in relation to something as serious as civilian oversight of the police force of this state. And so it's not remarkable that the committee, the Upper House Select Committee, formed a consensus that there should be an agency, a new unified agency, to end the multi-agency approach, which had been confusing, where each of them had the potential to undermine each other's findings and in turn undermine public confidence. Not only public confidence in oversight of the police, which of course is vital to public trust, but also a lack of confidence in the police force as an institution. And that's the ultimate victim. If the community can have no faith in the police force as an institution, that is a very real problem for law enforcement, because the police cannot do their job without the active engagement of the community. So it's a real problem. And it's also problematic when police have to investigate their own, particularly given the conflict of interest, as the committee noted, between police officers' obligations to their colleagues as well as to the public. And so the idea that a single well-resourced oversight body was a far preferable structure to the current structure is not remarkable, although of course it was good that all of the different political parties represented on that select committee came together in support of all of the recommendations, but particular recommendation 6, which said, and I quote, that the New South Wales Government establish a single well-resourced police oversight body that deals with complaints quickly, fairly and independently. Now, quickly and fairly is a very important thing, so you don't have a rerun of the still unresolved emblems matter and other matters of the kind that could be investigated. But it's also important that it be well-resourced, and I'll return to that matter in due course. I note that in the preparation of this legislation, this government has, unlike, for example, the legislation to deal with crime prevention orders that we dealt with in the past, this government has been very consultative around this. And on behalf of the opposition, who was engaged with at an early stage. I thank the Office of the Deputy Premier and Police Minister for that early engagement and multiple engagement. And I note also that the government has engaged with the Law Society and the Bar Association, as well as the Police Association, over, I think, an extended period, or certainly a period more extended than in relation to other significant legislation that has come before the Parliament, which I think is good, because it shows an acknowledgement and a recognition of the importance of getting this right, of making sure that there can be confidence in civilian oversight of the police force, not just by the Parliament but the wider community. And and the idea that it would be done in a narrow and partisan way would be highly problematic. And so I think the way in which the government has gone about this has been good. And what we have before us is legislation which seeks to preserve the existing range of conduct about which complaints can be made, provides the new body, the Law Enforcement Conduct Commission, with most of the existing powers enjoyed by the Ombudsman and the Police Integrity Commission and their functions to oversight complaints, and includes improvements including a positive obligation on police to report misconduct, provisions requiring the LEC and the police force to provide a complainant with the reasons for the decision made on their complaint, including a decision not to conduct an investigation, and of course provisions that enable the new body to oversight all critical incident investigations. Whereas under existing legislation, a critical incident investigation can only be oversighted by the Ombudsman if the incident was the subject of a complaint. So these are significant improvements to the architecture of civilian police oversight. But of course, as is the case when you're seeking to integrate a number of existing bodies with existing powers, of course each comes with their history. You don't always get it right, no matter how long or thoughtful the consultation can be. And I note that the New South Wales Ombudsman has articulated a number of continuing concerns about the legislation as it is currently configured, and those concerns are certainly shared by the New South Wales opposition, and I'll address those shortly. But just before I get to that, and I'm picking up on a point I think that was raised by the Honourable Michael Gallagher, of course, the core of this new body will of course be the space that was occupied by the Police Integrity Commission, and I won't dwell on that too long, but I think there's been a lot of criticism of that body, and much of it very accurately levelled at them, and certainly I don't think there will be a lot of tears shed over the departure of the Police Integrity Commission. But it's important that we create a strong and robust institution that replaces it, one that has a different culture, that doesn't repeat the mistakes of the past, and is one in which can lead to greater public confidence, not only in its own role as a regulator, but in the role of the police force. Now, one of the concerns the Ombudsman has about the current legislation is that the new body's own motion investigative powers would be limited to serious misconduct and serious maladministration in a way that was not only limited but inferior to the powers currently available to the Ombudsman and the Police Integrity Commission, and importantly is inconsistent with the Tink report, recommendations 1, 3 and 15, and in particular concern about the scope of clause 51 of the bill, which sets out the charter, if you like, for the Law Enforcement Conduct Commission. And without going into all of the details, there are concerns that the new body will not be able to investigate a broad range of conduct, for example, which the Ombudsman can currently investigate, including conduct which is a criminal offence that is not a serious indictable offence, unlawful conduct that is not an offence or corrupt conduct, police force maladministration that does not meet the threshold of serious maladministration under clause 11, or conduct which the Ombudsman considers should be investigated in the public interest but doesn't meet any of the serious thresholds required under section 51. And one example offered about this is the investigation into the use of police tasers, followed by a special report to Parliament in October 2012 called How Are Taser Weapons Used by the Police Force? And the investigation included a comprehensive review of over 2,000 taser use incidents and the police force systems, policies and procedures, including arrangements for ensuring proper governance and accountability for the misuse of the devices. And the investigation resulted in 44 recommendations for strengthening police systems, most of which was supported and implemented by the police force. The Ombudsman feels that it's unlikely that the new body would be able to commence such an investigation under the legislation now before the House. And if that's the case, that's a significant problem. And it's also problematic, of course, that the powers of the new body would conflict with and depart from the Tink report recommendations, because if that's the correct analysis, the new body would not have all the powers and all the functions and powers of the Ombudsman set out in Part 8 Capital A of the Police Act, or indeed all of the powers available to the PIC presently. There are also concerns articulated about limitations on the ability of the Chief Commissioner to make operational decisions, and in a way that is in conflict with the Tink report recommendations 9 and 11. Clause 19 of the legislation sets out the powers available, or the way in which the new body will work, decisions of the Commission, and it sets out that some are to be the powers of the Commission are to be exercisable only if 2 of the 3 commissioners agree, one of whom must be the Chief Commissioner. But there are some functions where the Commission can only exercise the functions where there is a unanimous decision of all 3 commissioners, and that includes, and this is in clause 19.3, a decision to delegate a function of the Commission, a decision to hold an examination or part of an examination of conduct that is or could be serious misconduct in public, or a decision that there are reasonable grounds to issue a search warrant. And the Ombudsman's concerns are that this could impede the operational effectiveness of the new body, and I must say that is a concern that I share. I understand the need for safeguards, and I understand some of the concerns that have been expressed about the conduct of the PIC in the past, where only one person ultimately makes the decision. But that is addressed by the requirement that the core functions of the new Commission can only be exercised if the Chief Commissioner and one of the other 2 commissioners agree. I think that is a sufficient safeguard. There are, it's not just the Ombudsman, but a number of bodies have expressed concern about the width of the definitions in clauses 9, 10 and 11 about misconduct, maladministration. They're extremely wide and may lead to confusion, but I think that's probably inherent in the desire to make sure that there is as wide a coverage of operations of the new body. But there is also concerns expressed by the Ombudsman about the oversight of critical incidents, and some concerns that the bill in its current form is not consistent with recommendations 43 or 45 of Mr Tink's recommendations. And I'll just identify a couple of issues. There is a concern that the new body would not have the right to attend interviews as an independent observer, and could only do so with the consent not only of the Chief Critical Incident Investigator, but also of the person themselves being investigated, and notes that there is no such restriction in the current system, and in particular Section 146 of the Police Act allows the Ombudsman to act as an independent observer in monitoring police complaints investigations. And of course the requirement that the person who is the subject of the investigation has to consent before this body could do its work, it seems to me is a curious provision, and even where there is no wrongdoing, of course if you're a serving officer on the ground and there's been a critical incident and this new regulatory body wants to investigate the matter, it would only be human nature to say, well, actually no, I don't agree. And I think it's a point It's an unusual provision and one which I think could seriously impede the function. Anyway, we have some other concerns. They will be dealt with by way of legislative amendments, and I look forward to the committee stage.
Thank you.